You know that feeling? A salesperson tells you something that really seals the deal on a product, but later you find out it wasn't exactly true. So when does a simple promise like that cross the line and become a legally binding part of the deal? All right, let's get into it using a classic example about a misleading guarantee.
I mean, think about it. It's a situation we've all been in. You're about to pay, and you're told a product has some specific feature or a special warranty. You agree, you pay, and you walk out. Is that verbal promise you just relied on actually enforceable? That's exactly what we're going to unpack right now. To really figure this out, let's just follow a super simple story. It's a scenario that honestly probably plays out in stores thousands of times every single day.
Okay, so this is Helda. Her goal is simple. She just wants a good quality toaster, something that's gonna last. So she heads down to her local electronics store, Hardly Normal, and starts talking to a salesperson. The salesperson, Claudine, points her to a specific model and makes two really key statements. First, she calls it a high-performance appliance, okay? And second, she says, very clearly, that it comes with a 5-year guarantee. And based on that, Helda decides, yep, this is the one, and she buys it. But you know how this goes. Helda gets home, she's all excited to unbox her new toaster, and boom, she hits a snag. The promise and the reality, they just don't match up. And here is the problem. Claudine promised. She said the words, 5-year guarantee. But the official warranty card in the box, it says 1 year. That is a pretty massive difference. So this brings us right to the heart of the matter. What can Helda actually do here? Was that promise from Claudine just friendly sales chatter, or was it an actual legally binding term of the contract she just made? To answer that, we've got to understand two key legal ideas. First up, we have what's called a contractual term. Just think of this as an official, written-in-stone part of the agreement. If a term is broken, like a company not honoring a 5-year guarantee that was part of the deal, the person on the other end can take legal action for breach of contract. Simple as that. But on the other hand, you have something called a representation. Now, this is a statement made before the contract is even formed, usually to, talk you into buying it. And here's the really interesting bit. A representation might become a term, but it isn't automatically one. The courts have to step in and try to figure out the real intention behind the statement. So how on earth do they do that? How does a court decide if a salesperson's comment was just a casual remark or a binding promise? Well, they actually use a pretty straightforward 3-factor test to get to the bottom of it. So here's the test. First, they look at timing. Was the statement made right before the deal was closed? The closer it is to the moment of sale, the more likely it's a term. Second, importance. How critical was this promise to the buyer's decision? If Helda only bought the toaster because of that 5-year guarantee, well, that gives it a ton of weight. And third, expertise. Did the person making the statement, in this case Claudine, the salesperson, have special knowledge that the buyer, Helda, did not? So the whole point of all this is that the court isn't trying to read minds. It's looking at all these circumstances to answer one fundamental question. Did the person making that statement intend to be legally responsible for it being true? Okay, now let's take this legal framework and apply it back to Claudine's 2 statements to hold up. Let's see how they hold up. And right away, you can see a huge distinction. The statement that the toaster is high performance, that's pretty likely to be seen as just an opinion. Lawyers have a great word for this, puffery. It's subjective sales talk. But the claim of a 5-year guarantee, that's something else entirely. It's a specific, measurable, factual claim. Exactly. Because that 5-year guarantee is a concrete fact, and because it was probably really important to Helda's decision, a court would be way more likely to rule that, yup, it was intended to be a binding term of the contract. It wasn't just an opinion, it was a specific promise. But hey, let's play devil's advocate for just a second. What if, for some strange reason, the court decides it wasn't a contractual term? Is Helda just out of luck? No way, not at all. This is where consumer protection laws come in and provide a really powerful safety net. You see, the contract itself isn't the only source of Helda's rights. Even if that guarantee isn't an official term of the contract, Helda still has other really powerful options. She could argue it was a misrepresentation that basically tricked her into the deal. Even bigger, she could take action for misleading and deceptive conduct, which is flat out prohibited under laws like the Australian consumer law. I mean, these laws are specifically designed to prevent this exact kind of thing from happening. So, what does all this mean for you in the real world? Here are the key things to take away. First, know that a salesperson's verbal promise can absolutely carry real legal weight. Second, get good at telling the difference between a verifiable fact and just a simple sales opinion. Third, remember that powerful consumer laws exist to back you up. And finally, the entire context of a sale, what was said, when it was said, and who said it, all of that really, really matters. This whole case is just a great reminder that our words, especially in a business setting, have real weight. So the next time you're making a big purchase, just think about what's being said, what promises are being made, and are they just a little bit of puffery, or are they a guarantee that you can actually count on?